Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about color of right. Cases that should have gone to the Supreme Court of Canada, but didn't. Color of right is an interesting defense that applies in circumstances typically where something is being taken or attempted to be taken, and a person relies on color of right to justify their actions in taking it back because it belongs to them. And this argument was brought up in the context of anti-deforestation protests that were occurring in British Columbia, where there were orders made by the court enjoining activists from participating in protest activities in certain areas. As a result, some of the people who were subject to those court orders violated the court orders and were charged with contempt of court because they believed what they were doing was consistent with their color of right. And this was the argument that was raised, that Indigenous people attempting to defend the land that belongs to them and taking actions that were necessary to prevent harm to the land that belongs to them were justified in taking those actions, such that the contempt of court charge had to be dismissed because of the color of right defense. It is a fascinating application of that defense, and it's a defense that rarely gets considered on a regular basis, especially at the appellate level. And this is the exact type of thing that the Supreme Court of Canada should be considering: the limits of the color of right defense, the application of those types of defenses in relation to land defender actions, and a consideration of Indigenous issues. These are the things that are of national importance. This is not the only protest that's going on where there are court orders or injunctions. These are not the only protesters who feel that they may have some legally justifiable pathway to support their violation of court orders. And so the Supreme Court of Canada ought to have recognized this as a way not only to put the guardrails in appropriate places on the charter protected right to protest, but also to put the guardrails in appropriate places on the use of the defense of color of right and on the use of contempt of court proceedings against people who are actively exercising their constitutionally protected rights. Unfortunately, it is going to take another protest, another contempt of court charge, and another case before the Supreme Court of Canada may have the opportunity to hear a creative argument like this again. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Please like, subscribe, and share with your friends.